I'm sort of going to be the glue holding this presentation together, and I take full responsibility if it falls to bits. I've got to do some housekeeping, principally for those of you that are here, although if you need guidance as to how to find your exit if you're watching this on the live stream, I suggest maybe just standard normal office configurations, turn around, there might be a door, go for it. So here, if you're at the Law Society, in the unlikely event of an emergency, the closest emergency exit is located out of the main doors to this room and to the left. Those are the doors you came through. Is that right? Yep, good. This will take you down the main foyer of the building. The assembly point is outside the front of the building. Very interesting stuff. Important to know though, health and safety, very important. Bathrooms. Bathroom breaks are also important, although frankly you will not get the most out of this seminar if constantly you're getting up and down. But I think the main issue to say is that caution, you can get stuck in the stairwell unless you have a card. And getting stuck in the stairwell is probably not the right way to get back into this place to listen to what we're telling you ASAP. So in the unlikely event that you do decide you need to go to the toilet, don't forget to grab the swipe card hanging outside the emergency exit door. Don't do anything silly with the swipe card in the toilet, and use the swipe card to get back. Now, we are live streaming this session. That was what the technical delays were for just now. People at home, I'm extremely sorry if you experience some sort of cutouts and other things. It's because my very advanced Windows PC is much more sophisticated than the Law Society's HD thing seems to be able to deal with, but I'm pretty sure the tech guys have sorted it out. There was some sweaty moments just now. So we're live streaming. If you're going to ask a question and you're in this room, wait for the microphone, because otherwise people at home won't be able to hear you. If you're not fussed at whether people at home hear your question because you might think it's a silly question, then by all means don't ask or don't wait for the microphone. Then no one will hear your silly question except those in the room. And what do they call those rules? The Chatenbury rules, that what stays in the room goes in the room, stays in the room. And I have to remind you to fill in your CPD forms before you leave. The spares are on the registration table. If you're at home, I'm pretty sure you can just fill your own in, or maybe do something really exciting for the auditor, like take a selfie of yourself next to your screen and me. That would be a good idea. I'd really like to do that. I'd love to see that if I was the auditor, because it would be much more exciting than seeing their usual pieces of paper. Anyway, right now, I'm going to welcome you to this seminar and let you know what you have in store for you, because hopefully this isn't going to turn out to be an ordinary seminar. The only thing or only use for this lectern at the moment is to prop up the sophisticated laptop to hopefully keep it working. I'm not going to stand behind that, and neither are any of my co-presenters, because we all decided we didn't really like standing up talking head presentations. So in aid of that, I'm going to wander around a bit. I can go as far as this, apparently, before I disappear from the screen, which that would have been very effectual to the audience at home, and I can probably also walk this far. I've got to test the limits, and then I disappear from screen. So we're going to use this sort of working space to relax. I'm not sure how close I can get to the camera. I won't try that. Anyway, I'm a lawyer member of a standards committee. In the course of doing what I've been doing for the last few years on that standards committee, I thought it'd be a good idea to maybe do a little talk to lawyers about what that involves and the processes. And I thought there's not much point just hearing from me, because you hear from lawyers all the time. You should hear from some other people that are involved in our process as well. And that's what we're going to try and do today, because I've got two lay members of standards committees together. You won't be able to see this on the screen, but those of you who are here will see them. They're the older looking gentlemen to my right here. The one without the hair is actually the newer of the standard committee lay members, which is somewhat surprising. And the one with the hair is David, and he's sat on a standards committee for 9 years, and that means he's timed out, or tagged out, if you like, because you can only sit on a standards committee for the maximum of 9 years. And David has done his time, and he had bright ginger hair before he started, and now it's a sort of faded white colour, like you will see. Barry is the new recruit. He's been doing it for 8 months, I think we determined. And he tells me he enjoys it greatly, although he might be lying. I don't know. We'll have to see. Next to them is Susan Lovey. Susan's very concerned that she not hold herself out as a lawyer at the moment, although she has been a lawyer. I first met Susan when she was a lawyer, and I was not yet a lawyer when I started out at Russell McVeagh many, many years ago. Susan now, although she's not a lawyer, does know law, and is what they call a legal standards officer. So her job is to manage and to help run one of the standard committees that sits in Auckland. And so she brings to that administrative role a lot of her legal knowledge and her highly skilled organisational knowledge, and she'll explain to you shortly just how she goes about doing that and what she does. So one of the reasons we wanted to do this seminar and to do it a bit differently is because we all thought that lawyers need to start to understand the processes that the standards committees go through a little bit better, and they probably also need to start thinking a bit differently about these processes. So we thought hearing from people with different perspectives would be a good way to explain that. And in the course of doing that, we thought, well, we'll discuss a hypothetical complaint as a great way to spark some different thinking in your heads. So what we hope you're about to experience is an educative session that's going to be delivered in some short bites, intended to take you in a nice, easy way through the processes that you will see occurring when any complaint to a lawyer is received by the Law Society. So the scenes that will follow the process as it might occur. It starts with, of course, the complainant, and it will go through what we call the initial investigation phases to a hearing that may or may not occur. In the course of highlighting that process and all those little steps, we'll highlight some of the different ways that we've actually, as people sitting on standards committees, have seen lawyers react to complaints when they're confronted with them. And hopefully from that we're going to give you some things to think about and some things to reflect upon should you ever get a complaint about you in real life. So we're going to do a number of little scenes, and then we thought we'd call for questions at the end of that scene just briefly from either the internet feed or from the people that are here, and dealing with a few of those. But if you want to ask some more in-depth questions, we can then come back to that at the end. So all complaints start with a complainant, and the hypothetical that we want to introduce you to features a complainant called Mr. Chapman. And he's got a beef that actually quite frequently presents itself to standards committees, and it relates to wills and estates matters. If you've read the materials that's been distributed, you'll understand a little bit of what Mr. Chapman's beef is, and you'll also have learned that wills and estates, together with family and property matters, account for something like 60% of all the complaints that the Law Society receives. So if you practice in those areas, that's something you should certainly be alive to, and you should presumably be thinking about strategies to help you avoid the situation that our hypothetical lawyer, a man called Jacob Wormwood, faces with Mr. Chapman. So with no further ado, I'm going to let Mr. Chapman explain to you just what sort of problems he has.
I'm telling you all, you'd never want to go through the sort of troubles that I've had in the last 3 years. I mean, it drives you crazy. But I'm starting in the middle. I should start at the beginning. Look, 3 years ago, my mother, Nora Lee Annie Chapman, died. Who would have thought she was going to die? She was a sparkling 102-year-old. She was gone. And I was just so flabbergasted. But I said, don't worry, because my sister had been appointed by her as an executor. Now, my sister's not the brightest flower in the world, but at least she's going to protect her family, right? Wrong. A couple of weeks after my mother died, this Jacob Wormwood popped up in my life. I found that my mother, some years ago, she hadn't told me, had appointed this guy as her executor of her will. Not me, but this unknown lawyer. I thought, well, that's all right. He's a lawyer, an up-and-standing member of the community, so I rang him up, and he wouldn't take my call. So I thought, well, what do you do here? So I thought, think, Peter. I'll send him an email. So I sent him an email, nothing. Kept thinking it through, so I kept on badgering him. I didn't want to badger him, but I thought he's got to answer something. And one day I caught him in the street, and he wouldn't talk to me. He said, look, you're not my client. You're what's known as a residual beneficiary, whatever that is, that I cannot talk to you until the will is completed. I said, fine. When is that? He said, when it is. I said, well, who do I talk to in the meantime? He said, talk to your sister. So I went and talked to my sister, who said, talk to Mr. Wormwood. So there I was between the two with no one telling me anything. And I'm telling you, it's a very, very, very frustrating place to be. No one talking to you. You know you're a beneficiary, but what am I a beneficiary of? I'll know in due course. So this went on and on and on until finally I snapped. And one day I went up to Mr. Wormwood's office and banged on the door, and this little menial came out and said, he's not here. Well, where is he? He's down country talking to a client. Well, I said, I'm a sort of a client. I don't believe you. I want to see his office. I thought he was going to kick me out the door, and the silly fool took me into Mr. Wormwood's office, and there it was. There were piles of paper all up to the floor of the ceiling. It was like Brexit. It was a complete mess. So I had a look around, and obviously he wasn't there. I did peek behind some of the piles of paper. He wasn't hiding there. I peeked behind the desk. No, he wasn't there either. So I thought, well, he's not here. And out I went. Now, you'd think that would be the end of it. No. Some while later, I've been accused of stealing a file from his office. You couldn't find a file in the office. There were files dating back to 1822, as far as I know. Just hopeless. And so this went on and on and on. And then my friend Seamus said, don't worry, you can complain to the Law Society. They're a good pack of people. They'll look after you. How do you do that? He said, I've got the bit of paper here. So I scribbled out a bit of paper, had a look at it and thought, no, that's not going to do. So the next day I sat down with Seamus, who used to be a lawyer. I think he got struck off somewhere along the line. But he said, I'll help you. And we did this nice letter and we sent it off to the Law Society. Now I'm waiting to see what happens. And I guess you are too. So thank you for listening to me. I still think he should be struck off.
Okay, Peter, sit down.
No, I want to be heard on this.
Okay, you can calm down. Sit
Do you want me to sit over here?
You've had your say now. That's lovely. Thank you, everyone. Peter, well done. So it's great that you've showed a lot of respect for the complainant, because I think complainants deserve a lot of respect, and some of them need a lot of love, like Peter. We'd ordinarily have some questions at this point in time, but I really don't think that would be very productive. No, you won't. And one of the challenges we sent you, if you've looked at the materials, was we asked you to read this complaint as it would have been sent to you by the Law Society, with some helpful materials and some explanation of the issues that the Law Society had then identified, and we wanted you to identify your reactions. I'd initially thought I want people's emotional reactions. We saw a little bit more than that, but I thought I'd show you what these things looked like yesterday. This is the word cloud that you would have seen if you'd filled in the Mentimeter. If you'd come in early, you would probably not have seen so many words. We see a number of things that obviously the more those words are used by people, the bigger they become. So frustration, annoying, annoyed, concerned, confused, stressed, dread, stressed, anxious, worried, ridiculous are all the things that jump out from that word cloud as the emotional reactions that you as the lawyer might be feeling. It's good to feel this and express this. I hope you found that a cathartic exercise. I looked again just before the seminar started because I figured, like most lawyers, lots of people would have done it just at the last minute, and I was right. That's the word cloud. That's the word cloud today, this morning, literally 20 minutes ago. Once again, we see those large words: frustrated, frustration, concerned, angry, concern, confused, disappointed, anxious, stressed, coming to the fore, and I think there's about 140 responses there. I'll email that round everyone so they can look at the other smaller words. There's a number of lawyers that didn't respond emotionally, but they responded as maybe lawyers are wont to, in an analytical way. There's others that I'm pretty sure. Oh yeah, I had set the like there's a swear setting, so that if people tried to swear, it would have suppressed those things. So there's the odd F, which is meaningless unless you understand that there's the anti-curse setting. I've done nothing wrong, take a deep breath. I thought that was interesting. I quite like word clouds, so that's why I did that. And it was also a prompt for you to then test yourselves and ask some questions about what you knew about the Law Society's complaints process. It appears that people knew quite a lot. We'll come back to maybe those results at the end. But moving on to our process. So the complaint has been sent in and the Law Society will receive it. And who better to explain what the Law Society does with that material than the Legal Standards Officer, Susan.
Hi. Hi, I'm Susan Lovies and I'm a Legal Standards Officer at the Auckland office of the New Zealand Law Society, and I work with an Auckland Standards Committee in an administrative manner, so I get matters ready to go to the committee. I deal with the correspondence between the lawyers and the complainants and prepare, put the material together that goes to the committee. Under the Lawyers and Conveyancers Act, all complaints have to be referred to a standards committee. It's not the Law Society that's considering your complaint or the Lawyers Complaint Service. It's the standards committee. The standards committee comprises 7 members usually. There's 5 lawyer members and 2 lay members, and they are all appointed by the New Zealand Law Society Board, and they're all volunteers. And the decision-making power rests with that committee. The Lawyers Complaint Service is providing the administrative support for those committees, and it is required to deal with complaints in a fair, efficient and effective manner, and that's our statutory obligation. I'll run briefly through what happens when we receive a complaint. All complaints are initially processed in the National Office in Wellington, where they're triaged and assessed for suitability for early resolution. The complainant is asked to provide supporting documentation if that has not already been provided. And in a claim such as the one we see with Mr. Wormwood, Mr. Chapman would be asked to provide a copy of the will and any supporting documents that he has that will help the committee determine his complaint. Complaints which are considered suitable for quick resolution are referred to a Early Resolution Service Committee down in Wellington. And this is a special standards committee which is set up to deal with the most simple and non-contentious complaints. And they usually fall into 2 categories. The first is complaints that on their face could easily be resolved between the parties with a little assistance. And the standards committee can authorise a standards officer to ring the lawyer, say if documents haven't been released, say, well, do you think you should just release those documents? And if the parties can agree, then the complaint will be dealt with and no further action taken. And the second main category of complaints which go to early resolution are ones which are misconceived or outside the jurisdiction of a standards committee. So examples being lawyer for the child complaints, where they should be dealt with in the family court, simple fee complaints where the fee's less than $2,000 and there's no other conduct issues identified. The lawyer will always be notified of the complaint and given an opportunity to respond if they wish to, but the committee in the ERS thinks that it's able to make a decision on the information that's currently available. If a complaint's not suitable for ERS, then it's put on the standard track and usually allocated to a standards committee in the area where the lawyer is situated. So in the Auckland office, we deal with mainly complaints about Auckland lawyers, though we will get a few from outside if there's conflicts issues in other areas, or just capacity if sometimes one office is busy and the others isn't. So that's maybe why your complaint's not being dealt with in Auckland, if you're an Auckland lawyer. So this session is dealing with standard track complaints, which is what we deal with here in Auckland. And when a complaint file arrives on my desk, it's already been declared unsuitable for early resolution, so it's being dealt with on the standard track. And if a complaint's allocated to my committee, then I'll read through the complaint and supporting material and try to identify the conduct issues that are raised. Because sometimes the complaints aren't very clear, sometimes they're long, complex. The most complex I could think of was a complaint that was 145 pages long and accompanied by 2 Eastlight folders of documents. So you've got to actually read through it and try and assess what is this complaint about. And I give reference to I'll look at the rules, look at the legislation, the regulations. If you've got one of these on your desk, just be aware it's out of date. I use my well-thumbed version that I've downloaded to be up to date. Now, so I will identify the issues and send out the letter to the lawyer. So the lawyer, the sample letters that you saw in the materials, I'll identify what I think are the complaint, the issues that have come out of it. I've put 3 in there. Which rules or regulations I think we'd like to hear from the lawyer about. But those issues are not fixed at this stage. You know, as the complaint goes through the process, new issues may arise. The committee may be satisfied with the response received from the lawyer in relation to a particular issue and not want to pursue it. So those are just a guideline for the lawyer at the stage that these are the issues that we think arise out of that complaint. Most complainants will fill out the complaint form, which they can download from the New Zealand Law Society website, but we also accept complaints by way of letter or email. We don't require them to fill out a form if they don't need to. The lawyer is given 3 weeks to reply. That's our standard 3 weeks, though we are flexible within reason. If there's a valid reason why you can't respond before the given deadline, then we're open to granting extra time if that's appropriate, though we always have to be aware that we've got to deal with complaints expeditiously. But if we are flexible if there is a good reason why you can't respond within 3 weeks. The response you send in will then be sent to the complainant, who's given an opportunity to comment on your complaint before it goes to the Standards Committee. So once I've received the complaint, the lawyer's response and the comments, those are all packaged together and it's ready to go to the committee at that stage. We don't ask for further comments from the lawyer because we've got to end it somewhere, otherwise it just keeps going tit for tat. So we cut it off, but if there's anything the lawyer particularly wants to comment on, we accept further comments and they will be referred to the committee. And so but it is important to make sure those are provided as soon as possible to enable them to get into the agenda, because the agenda will typically be prepared a week to 10 days prior to the meeting and circulated to the committee members to read. And in Auckland we would typically have between 12 and 18 matters listed for each meeting, a variety of initial considerations, hearings, investigations, and a typical agenda will contain about 2,000 to 3,000 pages, which the committee members have to read. So bear in mind the amount of material that they're having to read, and so we suggest that you try and keep it concise and identify the key documents which you want the committee to look at. And all correspondence and supporting documents received from both the lawyer and the complainant go to the committee. So the committee sees everything. And to assist the committee members, the legal standards officers prepare an agenda note for each item prior to the meeting, just sort of setting out the background and summarising the issues. It's not so important in a small complaint like this, but when you get some of the complex complaints, it just assists the committee to know what the complaint is all about before they start reading the documents. And in the second emailing we sent you were provided with examples of the responses that Mr. Wormwood provided, and the response received from the lawyer does affect the way the committee deals with it.
So that sort of brings us to our first question time. If you'd like to ask any particular questions of Susan now, if you're here, wait for the mic. And off we go.
How often does the Standards Committee meet?
Once a month.
Right.
Yeah. So you have to wait for it has to be allocated to the next meeting once we've got everything ready.
You mentioned complaints against lawyer for the child are sort of dismissed summarily. That was the impression I had. What can you just talk a little bit more about that and how that works and why that is?
It's not an area that I deal with, but I understand that the lawyer for the child complaints are supposed to be dealt with by the family court, because the lawyer for the child is appointed by the family court. The first port of call is to go to the family court. So they would be, so the early resolution committee, the Law Society can't do it, it has to go to a committee. So the early resolution committee would say, well, this is a matter that should go to the family court, and it would be they would issue a decision saying that.
Because the lawyer was appointed by the court?
Yes.
Yeah.
Yes.
Susan, good afternoon.
Hello.
I just have a question about the ERS, and it's this. by the time the complaint gets sent to the lawyer, if I understand you correctly, it's been to Wellington through the triage system,
Yes.
assessed for ERS, and determined unsuitable. Is that then the end of the matter? Is there any ability on the part of the lawyer who's complained against to say, well, actually, I think this can be speedily
ERS?
resolved? Can it go back to ERS?
We do get people that ask that, but no, it would probably just be easier, just once it's been referred to the Standards Committee, to get it on for initial consideration quickly. And we can, if the lawyer and the complainant, get their responses in really quickly. And I know one complaint where we were able to get it to the Standards Committee within a month, and they decide to take no further action because they don't think that there's the Standards Committee they prefer, once it's come up to Auckland, to stay in Auckland.
If that is so, is that the appropriate time to suggest mediation or something similar under whatever the relevant section is?
You can, yes. That's one of the, if the lawyer wants to, often I've had a lawyer will write it and say this is appropriate for mediation, and we can then ask because of course mediation being consensual, we'll ask the complainant whether they're happy to mediate it, and then when it goes to the initial consideration to the committee, I'll note in the agenda note that both parties have agreed that they would like to take this to mediation, and 99% of the time the committee will say yes, let's send it to mediation.
Thank you.
More? Just one or two more? Yep.
Who appoints the mediator and who covers the mediator's costs?
Okay, we'll deal with that later, but we have a panel of mediators who've agreed to give their services free of charge, so there's no cost involved to the parties of attending a mediation. If they've agreed to mediation, I will normally, it's a matter of availability of mediators, so I will approach someone on the list and tell them the names of the people, so that if they've got a conflict they'll say no. But yeah, find an available mediator who's not conflicted, and then it's a free of charge service.
All right. Thank you, Susan. We're going to now move on. So we've got the complaint, we've got the response, we've got the reply, the agenda notes have been prepared, and Susan has circulated those things. So we thought we'd ask our most experienced lay member here to walk you through the process of preparation that he's forged over the last 9 years, and to talk about how he goes about approaching a meeting. David?
Thanks, Julian. So the first thing I received as a member of the committee was an email from the LSO. I received 2 every month, one from an Auckland committee and one from a national committee I was on. I still don't remember how that came about to be on 2 committees, but I was lumped with it. From the email, I got a secure link to a Dropbox, and in that Dropbox was the full agenda for the upcoming meeting. And there was the individual agenda items, and then in a structured manner under that were all of the documents in chronological order from the complaint through to the most recent correspondence detailing the whole file. And it was those items that made up those 2,000 to 3,000 pages. So my process was obviously first to look at the agenda for the meeting, because the complaints fell into 3 categories. The first of those was the initial consideration by the committee, and that was new to everyone on the committee. That was the very first time anyone saw it. So they required a very thorough reading, not just the agenda. They were very well prepared, the agendas, but I found it necessary to read the complaint, how it was written and the way it was expressed by the complainant, along with the initial response from the lawyer involved. The second category was those that are in the system, so to speak. They are before the committee and they're working their way through. The summary for those just stated clearly what the committee needed to consider at the particular meeting. These are working through, they might be waiting for documents from complainants, from lawyers or third parties, and weren't ready for a full consideration or for determination. They required less reading because committee members were familiar with them. It was just, what stage is it at this month? Some of those had a short life of a couple of months, but sadly, in a number of cases, that category of complaint, some of those were on the agenda for a year or more before they were determined. The final category were those cases, those complaints that were going to be dealt with at the next meeting as a hearing on the papers. So they were the full record again of the complaint, along with the notice of hearing and the submissions received by both parties. Although we would by that stage be very familiar with that particular complaint, those files required careful reading as well. So all in all, a lot of reading. And in the initial stages, over that 9-year period that I had, at the start it was all paper-based. So a courier would arrive with all these bundles of papers. But progressively that's got more and more electronic, and most of the committees just deal with it in an electronic form today. It was too much information to process in one sitting. So it was necessary to break it down, and working full time, inevitably that, as were obviously the lawyer members on the committee, was necessary to break it down, and was inevitably it was evenings and weekends where we're reading all these files. I found I needed to make notes as I read through, just for my own notes to jog my own memory, and some of the cases required quite a lot of thinking. Whether I was mowing the lawns or going for a walk, inevitably I'd be thinking about one of the cases coming up for the next meeting. So don't let me put you off joining a committee anywhere. It's very fulfilling, but there is a lot of reading. Now, I would have been assigned by the LSO to lead off the discussion about one or more complaints at the meeting. So in those I need, and we'll have an example of that shortly. So it just required a little more preparation to identify what were the key issues that needed to be discussed. The way in which complainants expressed their complaints differed greatly from very well structured. Some were getting legal advice in detailing their complaints, and others were just quite random. So if that determined how much extra work required to understand those complaints. And similarly for the lawyer responses, those that were well structured, that were responding to the complaint, not attacking the complainant or other extraneous elements, helped the committee to really focus on the issues. The Wormwood complaint we're going to work through now would just be regarded, I think, as a run-of-the-mill complaint. It isn't overly complex, and would be one we would like to think got through the process in a couple of meetings. So that's my observations there. Thank you.
So I've been asked by the tech people if we can take a 5-minute break when they're going to fix the glitch issues that people here might have noticed just a bit, but people at home, is there some haters on the internet right now? Okay, so yeah, 5-minute break, and then help yourself to whatever's over there because it's only going to go cold. All right. So I think we've sorted the technical issues that those at home were experiencing. And we're at the stage where the initial documents have been prepared, all of that reading that David's talked about has been done, and the committee is going to assemble. As I think Susan mentioned, most committees meet every month, and some meet over lunchtime, and if you meet over lunchtime and the Law Society remembers, you get a free lunch. The Law Society mostly remembers. which is good. So the Chapman complaint would of course be one of the items on the agenda for this particular meeting.
And at the initial meeting, the committee can't make an unsatisfactory conduct finding. That has, in order to make a finding against a lawyer, it has to go to a hearing on the papers. So when it goes to the committee for the first time, they can take one of 4 actions. They can consider the complaint and decide to take no further action if they feel that the lawyer has adequately explained and they're happy with the explanation given. They can resolve to investigate the complaint either by way of asking for further information, or they can appoint an investigator or a cost assessor. They can recommend mediation, conciliation or negotiation, or if they're satisfied they've got all the material they need, they can set it down for a hearing on the papers.
So right now we're going to role play for you how that might work in the Wormwood case, imagining of course, as you must, that there are 2 other lawyers sitting around the table. We see them here. We need 2 other lawyers because of course the rules require that there be at least 1 layperson and 3 lawyers to make a proper determination. So we've got this Mr. Stressed Out, he's very diligent, and a young lady over here who probably would be too young in terms of legal experience to sit on a standards committee because our rules exclude those with less than 7 years experience from sitting on these committees. That's something that I think the Law Society is looking at as part of their considerations of revamping it. Certainly one of my reflections is it wouldn't be a bad idea to have people with somewhat lower levels of experience on some of these committees, if at very least to open some of their eyes as to how some of the older members of the of the profession seem to behave. So here they are. They won't say much during our mock hearing, which would be unusual, of course, for lawyer members of committees, because in my experience the lawyer members of the committees often say an awful lot. So now we come to item 13 on the agenda, lucky 13, the complaint against Mr. Wormwood. Barry, that's been allocated to you. Could you start us off, please? I think it's on page 1753 of the materials.
Right, the complainant in this matter is a Mr. Peter Chapman, and he's complaining against Mr. Jacob Wormwood of Wormwood, Angle and Beavis. The circumstances are Mr. Peter Chapman's mother, Mrs. Nora Lee Chapman, passed away on the 29th of April 2016, her son being her sole means of moral and physical support prior to her death. Several years previously, the deceased had appointed Jacob Wormwood as executor and administrator of her estate, and had also appointed her daughter Cecilia Chapman as an executor. The complainant says his mother had told him she did not want to burden him further and that it was time for her sister to shoulder some responsibility for her affairs. At the time, the complainant accepted his mother's decision, but now feels Mr. Wormwood has, quote, exerted a corrupting influence on both my mother's estate and on his sister. The complainant says after his mother's funeral, he reached out to Mr. Wormwood to discuss his mother's will and, quote, hit a brick wall. He found that he was unable to make an appointment to see Mr. Wormwood. He was always too busy to see me. When he tried to talk things through with his sister, she replied he was placing her in an awkward position to speak with Mr. Wormwood. 3 years after the death of his mother, the estate has still not been distributed, which has made Mr. Chapman angry and frustrated. He says Mr. Wormwood told him, you are not my client, but a residual beneficiary of your mother's will, and that until the estate's debts and administration expenses are finalised, I will not be in a position to discuss your mother's will. Meantime, the complainant learned his mother's property had been sold. He has no idea where the money from the sale has gone, nor does he know how much Mr. Wormwood is charging to administer the estate. He is presuming his sister is authorising such expenses, although she will not tell him what they are. He also has no knowledge of what happened to his mother's shares or the money remaining in her bank account. The complainant poses 5 questions. Why won't Mr. Wormwood just talk to him? Why all the secrecy? 2. What has happened with the house sale? 3. Why can't he simply tell him what is going on in his mother's estate? 4. What has he advised his sister as co-executor? And 5. How much is he charging, and is there any oversight of his fees? He says Mr. Wormer's actions has placed him under considerable stress, that he has been suffering from shingles, which his doctor advises are directly related to the stress he has been put under. He has since produced a doctor's certificate concerning his illness.
So we're going to just freeze there and imagine these people around me are staying absolutely still, like one of those internet things, because it's at this point that our pathways diverge. And just so we're all clear, that should now say 1. Brilliant, it worked, I didn't even need to look. Barry, pathway 1.
Right. I would go on then to say this. I'm impressed with the manner in which Mr. Wormer has clarified the issues relating to this complaint. He has step by step dealt with the complaint in a lucid and considered way that leaves little doubt as to the situation from his viewpoint. Perhaps the only question I have is whether he was wise to delegate the answering of Mr. Chapman's questions to his fellow executor, the complainant's sister. It may have been more efficient if he'd handled these matters directly with Mr. Chapman himself. I'm left with the feeling that there's been a breakdown of human relations in this matter and that over time has been exacerbated by misunderstandings between the parties.
So thanks, Barry. I think, Susan, we had 3 issues that we'd identified arose there. I tended to agree with what Barry's saying in terms of the report. Wormwood's given us the invoices, hasn't he, and his terms of engagement. I wasn't seeing anything there that jumped out at me in terms of them being unusually high or anything that really concerned me.
Did anyone have any problem with the quantum of the fee?
No.
No. There's this point about the invoices not being supplied to Chapman.
Yes, but I've referred you to that LCRO decision, which says that a beneficiary under the will should be entitled to receive the invoices.
And I think his response was he didn't realise that was what he needed to do. But regardless, as I'd read it, he'd given them to the sister.
He had,
and
the executor.
Was expecting her to be discussing the fees issues with the with the complainant. So it didn't seem to me that there was any deliberate sort of lack of transparency on the billing or anything, but this lack of communication or breakdown in communication between the complainant and his sister.
I thought Mr. Wormwood was entitled to think, well, I'm telling my co-executor of what's happening here, and to be entitled to think, well, she will be taking care or informing her brother.
It's a bit of a shame that it's sort of come to this. Barry, did you have any sort of gut feeling as to how you might want to move this forward, if at all, or?
Well, I still think from a common sense point of view that he should have been talking to Mr. Chapman directly. I mean, to rely on a sister, it leaves it open to all sorts of mishap. And I still think it's his responsibility in a common sense way to speak directly to the complainant.
If I hear where you're coming from on that, but if he's identified that there's a personality clash between him and Chapman and tries to resolve that by letting the sister take care of the communications, that seems to me he's trying to avoid conflict that has ended up biting him in the bum.
Yeah, I still think he's experienced enough to get over that initial hump of dealing with a difficult, if he is in fact difficult, and that it's his responsibility both as a lawyer and as a humanist to actually deal with this person in a common sense way.
David, you got any?
I think that's a bit tough. I think if you extrapolated that out and there was multiple beneficiaries, would he have to do that with all of them? So I think we'd be taking too hard a line on that, on Barry's point.
Maybe we should just come back to sort of the issues that have been identified then and work through those. So, Susan, we have this issue about the invoices.
The invoice.
I mean, as long as I think there's transparency here, but just communication breakdown. So I'm not really that fussed on taking that matter any further, to be honest. And importantly, it seems to me, in his reply, Chapman actually hasn't said there's anything wrong with the quantum of the fees.
No, I'm agreeing with you on the quantum of the fees, but I did notice on the invoices he provided something. If you look at page 1862, there's an example of the invoice. And what I noticed is
page?
1862.
Okay.
And I noticed that the LINS charges and some of the other charges to do with the transfer of the property appear to be marked up they're significantly more than the standard LINZ charges. And you'll recall we've had a number of these cases where it's been determined that marking up those costs above actual is actually regarded as misleading conduct. And I think there's a risk that Mr. Wormwood may be applying that markup on all of his work and potentially affecting all of his
I hadn't noticed
clients.
that. I hadn't noticed that at all. Look at that. And it's on, is it on the other ones? It is?
Yes,
it's on
it's
all
on
of these
all of them.
invoices.
Yeah.
Goodness me. Oh dear.
So I agree, quantum is okay, but there's just that issue.
You may want to own motion for the invoicing issue, because that's really
Yes,
an issue that relates to his practice rather than this
Yes.
particular client.
I agree. On the merits of the complaint itself, I would be quite supportive of no further action.
Okay, let's come back to that. So we're all agreed that on item A, as the issue stands, we don't want to take that any further. We'll no further
No.
NFA that one.
Okay.
So item
NFA?
B. Yeah, item B.
Item B,
What's
whether
that?
he this is the issue of timeliness.
Right.
Mr. Chapman raised the fact that it's been almost 3.5 years since his mother's death, and the estate has still not been distributed.
I thought that had been completely explained by
Yes,
the...
Mr. Wormwood has explained that
Yeah.
that it was the issue with the unconsented work on the house.
And that looked like Chapman had, and once again, another communication breakdown, wasn't aware of it, but doesn't seem to quibble with the fact that it had occurred.
Mm.
And I think that would delay any distribution in this situation. So,
Yeah.
Okay.
so on that one, Barry, do you think we should...
I think that because local councils can get really tetchy about unauthorised work, I can understand that it could stretch out to 3 years. So I'm pretty
Okay.
relaxed about what Mr. Wormwood has explained, and I don't think that we need to go much further on that.
Okay, so I
Okay,
think...
no further action.
Mhm.
Okay, and issue C was related to the way he had dealt with Mr. Wormwood, whether he'd maintained proper standards of professionalism.
And we've got this usual, I was dealt with rudely as
Mm.
opposed
Yes.
to I was nice and polite but firm.
Mm. I thought the complainant was, by his complaint and manner that comes through the reading, was pushing it pretty hard. So to counterbalance that, what are we left with?
Yeah, look, I've seen those. I think we have to take a view on those that it has to be pretty extreme and almost
Mm.
uncontroverted.
Mm.
We've got no
Mm.
an independent view of that. The sister hasn't chipped in one way or the other.
No.
He did mention that he was going to get a note from the sister, didn't
Yes,
he?
we haven't received anything from the sister.
Right. Do we think that that it's a bit odd the lawyer hasn't put in that note just yet, but do we think that matters? Would you want to hold it over until we've received that, or?
No, I'm quite happy for the point that David's made. If there were multiple beneficiaries, then all he'd be doing would be running around trying to satisfy all of them. So I think that's a point well made, David.
Yeah.
Mm.
Okay. So I think we're agreed then. We
Okay,
NFA
no
on that one
further
too.
action.
Mm.
All right.
And then it just leaves us with the issue that David's identified with the marking up of the LINZ charges.
Yeah.
Whether
Yeah.
we want to resolve to open an own motion investigation in relation to that.
I think we almost have to, don't we? If we're sure
Mm.
that it's happened.
Mm.
So
Okay.
what
Own
will you do
motion.
on that one then? With the own motion, you'll
We'll own motion and open a new file.
Right.
Okay, shall we move on to the next matter?
So we're freezing again because that's how we dealt with pathway number 1. It should say 2 up there now. So we sort of do that. And Barry,
In pathway 2, I would end my presentation in this way. In response, Mr. Wormwood says the complainant is trying to impugn his professional reputation and states that since Mrs. Chapman's death, he and Mr. Chapman's sister Cecilia have attempted to realise the assets of the estate, repay its not inconsiderable debts and proceed to distribute the residue to the beneficiaries. He goes on to state that he is a busy man, that Mr. Chapman has no awareness of this, that he is constantly trying to make appointments even though he has nothing to tell him. Mr. Wormwood says until the residue is determined, he has no entitlement to anything. He states that Mr. Chapman's recent approaches to him have become increasingly rude and obnoxious, so much so that his sister has refused to deal with him. On at least 2 occasions he has come to the offices of Mr Wormwood with no appointment. On one of those occasions when Mr Wormwood was away, he demanded to see the office for himself. Mr Wormwood then claims that after that visit one of the files relevant to the issue to the estate went missing. Mr Chapman admits being in the office but denies taking the file. Clearly there's a serious breakdown of understanding between the parties. I would, however, bring to the attention of the committee Mr Wormwood's questionably aggressive comments in the opening of his letter to the NZLS, namely, "He has set out to impugn my professionalism. I am unable to let that lie without putting him in his place. He appears to have placed himself out on a limb and seems to be inviting me to saw that limb off. I shall not hesitate to do so." If this is the way he chooses to answer the complaint of this committee, one can only wonder how he has interfaced with and handled the ongoing relationship with Mr Chapman as he has tried to obtain information regarding his mother's estate. I feel the principal responsibility for answering Mr Chapman's question lies with Mr Wormwood, that his reply to this committee leaves a number of unanswered issues that need to be more fully explored.
Well, to be honest, Barry, I think you're being generous to him there. Has he actually given us anything that's relevant to the complaint that's been made?
No, he doesn't seem to have actually responded to the issues that we've put to him.
Right.
This is one of those cases I wished Mr Wormwood had got counsel or someone got some advice on this matter.
Yeah, you wonder what he's trying to achieve with the sort of the response. But there's no, sorry, we're right, there's no invoices?
No, he hasn't provided any of the
Terms of
invoices.
engagement?
No
Nothing
terms
back.
of engagement. No.
It just seems to be this, I'm a busy man, my professionalism has been impugned, and I think he's stolen some files from my office. Okay, well, it sort of makes the initial investigation on this reasonably easy, doesn't it? I'm
Yeah.
assuming we're all comfortable that we should be looking at this a bit more.
Absolutely.
And Susan, should we just sort of run through those issues?
Run
Is
through
that-
the issues.
yeah.
We've got the provision of invoices, that he has not provided invoices to Mr Chapman, and whether that's in breach of Regulation 9 of the Trust Account Regulations.
So he doesn't even tell us if invoices have been provided at
No,
all,
he
right?
hasn't
He's
responded to
confirmed
that
or
issue.
denied, so we almost have to take that further, do you think?
Yes, yeah.
And then issue 2, timely and consistent. I mean, this estate's been going on for 3 years. What's he told us about why?
No, he hasn't.
Nothing.
He's just referred to some inconsiderable debts, but he hasn't really told us what they were or why they've delayed matters.
Right. And then the proper standards of professionalism. Without wanting to prejudge it, if that's the way he's been dealing with Mr Chapman, then I have some sympathy with the complainant. But I'm not prejudging it.
No. So shall we? Right, so we're resolved to investigate.
Yes.
And do we want to get the lawyer's file,
Yeah, I think we're going to need.
Everything.
the file and invoices?
Yes.
Yes.
Can you direct him to make sure it's organised though? Because that last one we had where they just dumped that motherload of stuff and said, "Here, fill your boots." That didn't really, make for that.
Shall we issue a Section 147 notice?
Yeah.
147 the file.
Do you think he doesn't look like the sort of lawyer that's got it electronically, does he? You could ask if
We
he could
could
maybe provide it in an
electronic
electronic
form.
format that we could more usefully use rather than the usual boxes and papers and things.
Yeah.
You know, heaven forbid this be a lawyer of tomorrow.
Okay.
Okay.
We'll request it in an electronic format if possible. Okay.
Yes, that's good.
All right.
All right, dealt with. Happy? Next matter.
Mm-hmm.
And then we come to the last one where
Hang on. I've got to do number 3.
3.
it's a coup.
Right, Wormwood, item 13. Barry, page 1753.
Can I go?
Yes.
Right, Wormwood, no response. I would end it this way. To date, Mr Wormwood has chosen not to reply to the issues brought to his attention by the NZLS. Why he should choose to adopt this course of action is an unknown fact in this committee's consideration of the complaints that have been brought against him. It is my view that the committee should proceed with its consideration of the complaint as Mr Wormwood has been given more than sufficient opportunity to respond in a timely manner.
Are we sure he's got it, Susan?
Yes, he's been sent the complaint, he's been sent reminder letters. I think at one stage he actually rang up and asked for an extension, but which we granted him, but he still hasn't complied with that.
Right. All right, well, so does anyone...
Well,
Well, hold on. He hasn't He hasn't responded to the 147 notice.
No, we haven't 147 him. No,
No.
he's just had the initial
just
the
the
initial
email.
letter, which he hasn't responded to. Can we deal with it without his response?
Well, we don't have any. Do we even know whether there's been invoices issued? We
No,
have
we
no
don't.
explanation as to
No.
why it's taken 3 years,
No.
and we don't have any answer to the complaints about being rude and things like that.
No.
So, what if he doesn't comply with the 147? What are we going to do then?
Well, that's a disciplinary issue of itself. If a 147 note is issued and not complied with, that's obstructing a standards committee and its function. So we can own motion him for that.
And that would be misconduct, would it? Or
Possibly can go to the tribunal.
Right. Well, I suppose we start that process, don't we? And
Yep.
hope he wakes up and.
Yeah. Okay.
Is there a case that sort of talks about lawyers having duties of candour and to cooperate with standards committees? I'm sure there was something.
Yes, there is.
Yeah.
Yes,
Maybe when you go back to him, you should just give him a gentle hint that, that's sort of what lies ahead. The 147 has a bunch of warnings at the bottom, doesn't
yes, it? Yes.
Okay. Maybe for him, just make them in a bigger font.
Okay.
Yeah.
Okay. So that one we're resolving to investigate, and
Yes.
we're going to issue a 147 notice to require him to produce his file.
Yes.
Okay.
All agreed?
Yes.
Great.
Yes.
Move on to the next matter.
Okay, next matter. Now, so that's 1, 2 and 3 over. We crowdsourced your answers to this if you'd participated in that second Mentimeter thing. So we thought we'd see what everyone else would have done. It's not a bad idea to crowdsource the Standards Committee stuff, is it? People might get really interested in getting involved, and we'd turn it around really quick as a profession. So this is what you said about Pathway 1, so the good response. 29% thought they'd send it to mediation, 8% said no further action, 14 said they'd investigate.
Numbers. It's not
Does it not add up?
Yeah, it's not percent, I don't think.
Good grief.
It must be number of responses.
Okay, you got to know your IT, don't you? Okay. Well, sort of that big-sized yellow chunk said they go to mediation. The quarter-sized pink chunk would have investigated some of the issues. The slightly not so big-sized blue chunk would have, like we decided, not take any further action. So it's good to see we were in the minority. And the little tiny green chunk would have gone and investigated everything. Okay. Number 2. This is the bad response. So this is in percentages. The big size 55% green chunk investigate all. A bunch would have investigated some. 6% would have gone straight to hearing. A tiny percent would have said no further action, and 15% might have mediated. The committee, of course, decided it would investigate all. And then the third one, the nothing, no response, we had almost, how was that? 48% versus 55% investigate all. Amazingly, some people said no further action. A bunch would have gone to a hearing, quite on what, I don't know. 9% investigate some, and 9% would have mediated. So interesting. There's maybe some good training for Standards Committee hopefuls out there. Right. Off you go, because we've done our bit. We all bugger off having had our free lunch. And what do
And
you
it's
do?
back, it comes back onto my desk again.
Yes.
Now, so depending on what's happened at the meeting, it depends what I've got to do. Now, if the committee's decided to take no further action, then a notice of decision will be prepared and submitted to the committee. It will give the full reasons for the committee's decision, and it can take about 4 to 6 weeks for the committee to issue the decisions. There's usually multiple decisions and correspondence which comes out of a meeting, so we have to work our way through those. If the committee has decided to investigate, the relevant correspondence will be sent to the parties. This could be by way of a letter seeking further information or a formal notice under Section 147. A 147 notice must be complied with, and failure to do so is a disciplinary issue for obstructing a standards committee. If an investigator or costs assessor is appointed, formal delegations are put in place from the committee to the investigator or costs assessor. If the matter is going to mediation, I'll write to the parties and say that the committee strongly suggests that they mediate this and seek their agreement to mediate. Most people will agree to mediate if the committee suggests it. And once I've got their agreement, then I will arrange a mediator from our list of available mediators, and we're always looking for more if anyone wants some mediation experience. So they usually allocated a half day.
You don't get paid by anyone.
Pardon?
For that, you don't get
That's
paid by anyone.
No, it's a voluntary.
Right.
It's
You get a lunch if you have it here over lunchtime.
they're not usually over lunchtime, but they're usually a morning or an afternoon. And they held in Auckland. We held them in here at the Auckland office, and they usually allocated a half day. If the complaint settles at mediation, the complainant usually part of the settlement is that the complaint will be withdrawn. But that's not the end of the matter, because it still has to go back to the committee to assess whether there are any public interest issues that would warrant further investigation. And if the committee is satisfied there are none, then it will issue a no further action decision. Because if there's a settlement either at mediation or privately, there's usually no unsatisfactory conduct finding. But if there are serious issues involved, the committee can continue investigating, notwithstanding that the complaint has been withdrawn, and that's basically to prevent a lawyer buying his or her way out of a complaint. If it's something that has consumer protection issues that we think that this lawyer needs to have some sanction. And
I would have thought it would be rare for us to suggest a mediation and then not give it the tick off if it's settled, right?
It's more likely if often you can be investigating a complaint, then right at the end the complainant will say, just before you're all ready to go to your hearing on the papers, and then the complainant will write it and say, we've settled it, I'm withdrawing the complaint. And then the committee would look at, is this a valid withdrawal, or is it just the lawyer trying to throw some money at it to stop a finding. But yes, the committee wouldn't normally suggest something go to mediation, or if they thought there were serious issues involved.
There's two other aspects to the section that allows mediation, which, looking back over my time, I think have been underutilised, and that's negotiation or conciliation. So they can be a form of resolving those complaints without necessarily bringing the parties together in the same room, and I think could be used more, particularly the negotiated or some other form of conciliation.
We have tried conciliation in one I can recall where the parties were all in different cities, and so we got a conciliator to try and ring around them all and see if they could do something there, because it wasn't possible for them to all attend a mediation.
Did that work?
Yes.
Well, not the one that didn't. Your one might have, but the one I'm thinking of didn't.
People were in Australia and all around the place.
Okay, yes. And then you will have seen a reference in that to an own motion investigation, and the committee has the jurisdiction under section 130C of the Act to open an own motion investigation if it thinks, if it suspects there has been unsatisfactory conduct or misconduct. And in the example you just saw, David noted that there had been a inflating of LINZ fees, and that's something that is quite common, that is often referred to us by the NZLS Inspectorate, that a lawyer shouldn't be inflating the fees. They should, if you're charging a disbursement, it has to be just the amount that you've paid. You can charge a service fee, but that has to be clearly enunciated as being a fee, so that the client knows how much the actual disbursement was and how much of it is a lawyer's fee. So if the committee notices something like that, it can open an own motion investigation. The other types of own motion we get usually come from the inspectorate. If the inspectorate's had an adverse report, they will refer it to a standards committee to consider whether to open an own motion investigation. Another common one we get is judges will refer matters to the Law Society, if they've got concerns about how council has conducted themselves in a proceeding, and it will go to a standards committee to consider whether to open an own motion investigation.
Or even when I think lawyers have appeared as witnesses or done things or involved somehow in the litigation in another way. Yep.
And also when lawyers make reports, confidential reports under the rules 2.8 and 2.9, if you suspect there's been misconduct or misconduct you're required to report,
yes.
Unsatisfactory conduct you may report. And those, whether the lawyer doesn't want to make it an actual complaint, it will be put to a standards committee to consider opening an own motion investigation. And so once that's happened, I'll go away, I'll open a new complaint file. So this will be treated as a completely new matter. The complainant, Mr. Chapman, would not be involved in the own motion investigation because it is seen as to do with the lawyer's wider practice as opposed to something that involves Mr. Chapman. So he would not be involved in that at all, but the own motion would be opened and the lawyer would get an opportunity to respond. And then the last thing that could happen is if the committee's satisfied that they've got all the information they need, they'll set it down for a hearing on the papers, at which time a notice of hearing will be issued, and then both parties are invited to make further submissions. The issues in the notice of hearing may or may not be the same as the ones in the initial letter, because sometimes the committee will decide we're hearing on the papers on issue A, well NFA issue B, hearing on the papers issue C, so they may be satisfied with the response they've got on some issues but not others, or they may want to tweak the issue because it's not quite what during the discussion something may come out which is not actually covered by the issue that we've got in there already. So the issues that are contained in the notice of hearing are those that will be determined at the hearing on the papers, and the only issues that will be determined on the hearing on the papers, because for natural justice all parties have to be informed what those issues are and have the opportunity to make submissions. So you can make, you're entitled to make submissions. Not everyone does. Some people will just be satisfied that, I've already given you all the information in the response to the complaint, and that's fine if you want to just rely on the material you've already given us. But I would say you should carefully consider whether further submissions would assist the committee, because if it is going to a hearing on the papers, then there is a chance that there's going to be an unsatisfactory conduct finding, or if it's serious, a referral to the tribunal. So you'd probably want to think carefully before you decided to not make any submissions. And again, clear and concise submissions are usually appreciated by the committee, and it's best to ensure that you meet the given deadline, because the agendas are prepared a week to 10 days before. Obviously, if your submissions come in late, we will get them to the committee, but they don't have the same time to consider them as they've had if they'd gone out with the agenda documents. Because you remember that your matter isn't the only matter that's been considered at this meeting, so it's good to be clear and concise and identify clearly the key documents. And if you need extra time, it may be better to ask for an extension, and if there are valid reasons for an extension, they will be given, because the committee just wants to treat everybody fairly, and they wouldn't arbitrarily say you can't make any further submissions because you're late. So often it does that the committee will adjourn it to the following month if the submissions haven't been able to be given.
Okay, so we're not going to bore you with what a hearing might look like, but we're going to tell you what you might expect. And what you might expect is very similar to what we've just shown you in terms of the initial investigation, except depending on how the committee decides to run its workloads, you'll be item 1 or 2 or maybe 3 instead of item 13. And instead of it being perhaps a shorter discussion, because you can only have a short discussion if you don't have information, it'll be a much more extended discussion, and in our committee anyway, certainly everyone is expected to prepare fully to be able to engage with someone like Barry who might be leading it in terms of the hearing process. Some committees I know actually do the easy things first and then finish with the hard things. So you might see it down the list of agenda. My committee has about 2, maybe 3 max hearings each month. and they're right at the top of the agenda with the other easier things following that. So we're not going to role play that because the process is exactly the one that you've seen, with someone leading a discussion and people talking about documents, what they see, feel, think, hear. You'll have obviously the fuller file, and if, say, as in the Wormwood case, the whole file has come in, it might have been Barry's job, or Barry with someone else on the committee assisting, coming in at another time to look through the file and to find all the stuff that they think is relevant that should have been pulled out by the lawyer. There's a lot of things to think about if you're a lawyer and you're in a position where you're, I think, dealing with a hearing, because you can make the committee's job a lot easier if you take the time to make it easy to find the things that people need to find. And that's probably one of my reflections, is particularly if you're dealing with an unwieldy complaint where there's heaps of materials, a better reply from a lawyer that is a shorter and more focused reply, hitting the issues that the committee wants it to be addressed, is likely to be a much more effective reply than a uphill, down dale, go around the horses and expect the committee to find the answer for you. I thought we could best sort of address the hearing issue by asking what maybe David for some of his overall comments, and then Barry can give you his as the lay people that probably head spun the first time you did one of these meetings.
Okay. For the 9 years, my estimate is I probably participated in over 200 hearings on the papers. Although most were that, there were, in the earlier years, it wasn't uncommon to have oral hearings, and the Act allows that. They were useful when there were conflicting accounts between the parties that there didn't seem to be any other way to resolve. And although they were very time consuming, and it was quite unwieldy with, a committee of 7 or 9 people, complainants and lawyers and representatives, they seem to have reduced over time, but they were effective for certain types of complaints. As Julian mentioned, the committee is very conversant with a matter by the time it gets to the hearing stage. It's quite common for there to be input from another party. A lot of investigators have been used, whether they be specialists around conveyancing matters, trust account matters, or just fact-finding on certain cases. So you might have an investigator's report which has been shared with everyone, and also in fee-related cases you often have a cost assessor's report. Those sort of neutral party reports are very helpful to a committee and often assist to clear up some of the factual matters, quantum matters, and a range of different things. I just can reinforce the quality of the submissions and the structure of the submissions, and succinct really help to work through a hearing process. Some complaints are very, very detailed, and a forensic style examination has been required. Often in conveyancing matters it may be very relevant. The time documents were registered, faxes or texts received. I recall after the GFC period there were a lot of complaints on the Auckland committee I was on for alleged breaches of the solicitor's nominee company rules. The rules had changed at various times, and it was a real forensic examination. It might have not have been a breach in one particular era, but it may have been a couple of years later. So it can be incredibly detailed. Committee members typically have particular strengths and can be of enormous value to the committee as a whole. They may be trust account supervisors themselves. They might be more involved in litigation, whatever the matter may be. The conveners that I've experienced have all ensured that they engage with every member of the committee is asked for their comments or observations in regards to the matters before them. And almost all decisions are reached by true consensus. I can only remember probably 5 decisions that were arrived at by vote. They were, obviously a fairly close call, but most are definitely by consensus. Perspectives change during the hearings process. I would read and be thoroughly prepared, have developed preliminary views, but when we've gone round the table and all the opinions have been sought, there was often movement in the room before a decision was made. For lay members, and from my own experience, it takes a few meetings to find your feet, to get familiar with the committee's processes, but it's not long before you feel you're a full member of the committee. And I often found when a committee could have gone either way, that's when the convener would invariably say, what do the lay members think? Obviously looking sometimes for that consumer perspective, particularly when the meeting's been working through some fairly tough legal issues. Often it was late in the piece before, what's the consumer view of this? So they're my top of mind observations on the hearings process.
Okay, cool. Barry, did you have?
Yeah, I think from my point of view, after a couple of months, I was truly staggered, and that's the right word, as to how some lawyers had a complete inability to deal with other people, such as people who are unhappy with what they were doing. It's a matter of sort of human management and conflict resolution. And yet, time and again, I saw a lawyer digging a hole and digging a hole and digging a hole, and I was sort of looking down at that hole and saying, "Have you finished yet?" It's unbelievable. It's the nearest thing I can tell you is that in management, you get companies where there's a lot of unhappy employees. If you track through that, you'll find that the problem is management rather than the employees, and failing to resolve that feeling that they're not being treated fairly. And that's the issue. If you can head that off, sure, there are times when you can't. But if you can, you save yourself a lot of heartache down track when it suddenly becomes us against them, and a whole lot of things come up on our table here. The only other comment I'd make is the process on the committee that I sit on is incredibly fair. If I present something, and such as the wormwood thing, and it goes to the next committee meeting, it'll be someone else presenting it. So it's not me getting a fixed view trying to influence all the other committee. You'll get another view coming through that could change my view, and it has. It's very, very fair and balanced.
So, and then I'll give you some of my reflections. I've sat on my standard committee for 3 years. I think, as the blurb said, the reason I decided to put my hand up and go on the standards committees was I was reading these reports about what standards committees were doing and thinking this is crazy, and thought, well, I can keep moaning about it, or I can go and see how it works and understand it more and stress test whether it is crazy. And my eyes have seriously been opened as to the lack of quality of some members of our profession, I have to say, as to some of the stupid things that people do. If a file hasn't been billed for 6 years and you have $500 worth of WIP on it, are you going to bill it? If you do, and someone complains, I mean, I know it might be under the $2,000 threshold, but if I'm a customer and you just drop a bill on me that's 6 years old and you haven't had the courtesy of ringing me and telling me, well, I had some of this stale WIP or something, then you're living in a different world than I think most lawyers should be. One of my big takeouts is that I don't actually think, other than maybe the big firms, so we don't see many big firm complaints, right? Russell McVeigh's, Buddle Finlay's, Bell Gully's, they all sort their own stuff out quickly, promptly, efficiently and internally. So their internal complaints processes work. It's harder for a sole practitioner to do that, because the sole practitioner might be the only person that can deal with the complaint. It's not so hard for the smaller or mid-sized firms to do it, and often getting someone that doesn't know the file involved to help you try and resolve things can help you get out of your own way. And that's, I think, why we're meant to have these internal complaint processes, and I don't see them working very well a lot of the time, where say, for example, the partner that is in the fog of war, that has been donkey deep with the complaint and the client's moaning about fees and all sorts of other issues, keeps handling it and tries to handle it and tries to handle it, and does that badly because they can't see the wood through the trees. So often I think if that had been handed over to a partner in that firm, someone that was independent, who'd taken a fresh look at it, that can talk internally and then try to help the client resolve those issues, we wouldn't see half as many of the things we do have. I think for sole practitioners, and I don't know how you work it, but if you're in a network of people, it's not impossible to have independent people brought in at various points in time to help you get through those issues. Often we see complaints that are almost the last gasp of the client being so frustrated because they're not being listened to. And I find that really disappointing that as a profession we can't actually manage those things a little bit better without requiring it to come to a group of other lawyers. And then finally, the other thing that I find really, really quite sad is the practice of blaming the complainant, criticising the complainant for exercising a right we've given them to complain, or then, in fact, if the other complainant is a lawyer, counter-complaining against that lawyer. And some of the most troubling files you deal with is when two lawyers are just literally going hammer and tong at each other, each raising professional standards complaints against the other. And I don't think our committee is too much passion for some of disposing of some of those things. We look at it on its merits, but often they speak for themselves when it's just a tit-for-tat action. And actually some of them, we've looked at them, and it probably would surprise the person responding to the complaint that we would then actually find there's some own motion issues that they might have thought twice about raising if they'd really thought, because lots of people don't know the line between threatening to complain to the Law Society, and that in itself can be improper if you're using the complaint in an abusive way to try and get your own way. And that's a very common error that a lot of lawyers seem to make. So I think we need a bit more respect for our process, just generally, and a bit more, as a profession, I'm a member of the profession, I'm a bit disappointed that we can't sort our issues, the professional issues out a little bit more, in a little bit more refined and dignified way between ourselves without having to involve other lawyers in sorting it out. That's my rant and rave anyway. So we've taken you through the process start to finish. It will end on a hearing of the papers, and there will be a determination. As Susan said, it might take 4 to 6 weeks for that to be delivered to you. That determination could be, if it's really bad, simply a finding that this has been referred to the Lawyers and Conveyancers Disciplinary Tribunal. That's when you know you're in the misconduct territory, because the committee will have looked at it and decided this is more than just unsatisfactory conduct. This needs the more involved processes that tribunal can bring, and it obviously has more serious consequences. Decisions like that, and even the ordinary unsatisfactory conduct decisions, can all be reviewed to the LCRO. Trick for young players, you have 30 working days to do that, only costs about $50. Complainants all know this, okay, because if you get an NFA and someone like Mr. Chapman is sufficiently aggrieved, you could find that goes before the LCRO, and then the LCRO will be looking at everything the committee's done and deciding whether that was proper or not. Lawyers can also do that. Unfortunately, that LCRO process is often very slow, although I think it's sped up over recent years because they've got more resource there and they've been funded a bit better. But you have 30 working days to do that if you're going to do it. And that is a non-extendable time frame. And we've had some lawyers that filed on the 31st day, and you're gone. You will not get it in front of the LCRO then. No ifs, no buts, no extensions of time, no nothing. That's that jurisdiction. And they need the papers and the filing fee. Is that right? I think we had one where a lawyer was unhappy about what my committee had done, because we get told when our decisions get reviewed, and the particular lawyer had filed his paperwork but hadn't actually paid the filing fee in the LCRO until the 31st day. And that lawyer was told, no, you're a day out and there's no way to extend it. So 30 working days is quite a long time. It's like a month and 2 weeks, 6 weeks. You don't need to be doing, it's not a big form, is it, to fill out?
No.
I'm pretty sure it's the easiest form in the world. Are you unhappy with the Standards Committee? Tick yes or no. Enclose $50.
And then the LCRO will open up everything. If you've
Yep.
not just we've had ones where a lawyer has, there's been situations where a lawyer has gone to the LCRO unhappy about a determination, but the committee had actually decided to take no further action on some of the issues. But once it goes to the LCRO will open up everything, and there have been cases where they've actually upheld the finding and overturned the no further action decisions. So the lawyers ended up worse off for going to the LCRO.
So that's the end of our presentation. I'm conscious we sort of skipped questions because of the IT issues, but feel free to ask. And Katie, have you been like curating? So we've got some of the interweb feedback. I think we decided you give me your phone and I just scroll through and pick the ones I think I can answer. Is that what we decided I'd do? Oh God.
There's no lock on that.
You need some glasses.
Okay, so how about we go one from the floor, one from the phone? We split it up. Does the floor want to go first?
I'll give you time to read that.
It will do, yeah.
Does anyone have the right to attend the hearing on the papers? In the family court, we have regular hearings on the papers, but you turn up and present them and argue them with the judge. So I'm just curious to know,
No.
is this is a closed process?
Yes, it's a closed process. Neither party attends. And we're just not set up to
No.
do that. It's just with the committee process. It's we're dealing with multiple items. It's
Yes.
just too difficult. So it would only be very rarely that you can't. The Act is set up that the default position is a hearing on the papers. That there has to be good reason to take it to an oral hearing.
Just further to that, do the parties have the right to attend a hearing and listen to the
No.
committee's deliberations?
No.
It seems an anathema to me that that can be the case when you're dealing with a hearing in speech marks.
Well, we're dealing with the submissions have come in paper. We're just dealing it on the papers. So anything you wanted to put to the committee should be in your submissions.
Surely, but why should it be an inconvenience or put the committee out of its way, if you like, for any of the parties to actually attend and listen to the deliberations?
I don't know that the Act is
Well, one, we're not set up that
way.
way. Two, it's never been done that way. Three, seriously. Because, and I get where you're coming from, but...
Well, you're conducting a hearing involving parties, and essentially I would have thought that it's the right of parties to at least attend that hearing.
Well, no, so I think the Law Society would think and certainly you've got a right to be heard. That's in your submissions. You don't have a right to sit in and hear. But hey, we could set up a structure that way. I think with 1,500 complaints coming in a year, we'd need to probably double the amount of standards committees that we have.
You've got your review right.
Yes, and if it goes to the LCRO, you're entitled to
Yeah.
a hearing and to be
From there
attend.
there's appeal rights, right?
And there's appeal rights from the LCRO. Yes, so you can judicially review an LCRO decision.
And the LCRO is like de novo, right? So you're
Yes,
right back to square one
completely.
anyway. So
Yes.
you're
Yeah,
never
the
going to miss
LCRO
anything.
was, it's a funny little process when you think the LCRO does a hearing with people in person on an appeal from, effectively an appeal or review from a process that doesn't do that. That's the way it's been set up. The LCRO has same in the employment.
In the employment arena, yeah.
Yeah.
You can have a hearing. You can have a hearing on the papers by the Employment Relations Authority, and then you've got the de novo hearings through to the employment court.
Yeah.
Yeah.
The LCRO, I think, has had such trouble with its backlog that it's needed to get statutory amendments to enable it to deal in a more summary way with things. If people wanted a hearing in front of the LCRO, they could insist on it. Now I think they've changed it so the LCRO can say this won't be a hearing, it'll be a hearing conducted like the standards committees do. Keep going because Katie's phone's locked up and
It's kind of
why, what? Oh, okay. Okay. So someone said, I'm struggling to hear still. Really sorry about that. You should have asked that question a bit earlier. We could have fixed it. No, but seriously, someone said, how often do standards committees take action against complainants when it's found the complainants are vexatious?
I can recall occasions where the committee has reached the view that a complaint is vexatious. I can almost remember the section number, but there is the right for the committee to do that.
But what does that mean? You just say it's vexatious.
Mm.
Yeah, I think this person was saying
Often
take
people
action
have-
against
often
complainants.
people
We
have
no
no standing to bring a complaint is
Yeah.
one factor, but they can and have been deemed to be vexatious.
But we can't take any
We
action
don't-
against
No,
them.
no
other than
action.
other than
Doesn't
dismiss
declare
it.
them vexatious.
Other than
Dismiss
dismiss it under
yeah.
the grounds that we think it's vexatious. Yeah.
Yeah.
And would you say that to the complainant, that it was being dismissed?
The committee, yes.
Yeah.
It's one of the statutory grounds, isn't it?
It's one of the statutory
I think you
grounds.
try and word it a little bit more politely
Yeah.
sometimes, because it's sort of red rag to a bull if people want to take it further. And the vexatious ones hate to be called vexatious,
And we'll take you straight to
more
the
so than
LCRO,
others, I think. Yeah.
I'm incredibly vexed.
In some of the reading material that I looked at, and I didn't note down exactly where, but I've just noted down that 57% of complaints in 2019 were dealt with within 180 days, and that's usually around 90%. And I just wondered why it was so much significantly lower in 2019. Like, were there more complaints? Were there less?
No. So I think that's one of the slides, and I think a lot of people, by the look of it, were surprised by that. So the average disposal rate is about 60% in 180 days. 90% get dealt with within a year.
Right.
But by the looks of it, and if you think people are saying what, maybe if they don't know what it should be, it looked like everyone was wanting 90% within 6 months. But that's the 60%. I think last year there was a big drop off of that to about 20% for an unknown reason, and it might be because the ERS weren't able to get rid of so many at that very early stage.
Right.
Or, my committee has had some ones that are, what would be the oldest thing?
Oh, we've got one that's been around just about 2 years.
Yeah.
That's been to multiple cost revisions.
Yeah.
But yeah, if it goes to a hearing on the papers, you're probably looking at least 6 months, because by the time you've got the complaint in, got the response, got the comments, put it to the first hearing, then even if it goes straight to a hearing on the papers, it's usually not the next hearing, it's usually the following one by the time it gets on, because of the number of complaints we're dealing with. My committee sort of has been between 50 and 70 complaints on the go at once, and it's a matter of of juggling them and getting them on before the committee. So to take it right through that two-stage process is usually going to take about 6 months. If you get knocked out at initial consideration, obviously it's a lot quicker. But if the complaint needs, if the people aren't giving you enough information and you have to keep going back and asking for things, it drags it out. And if it goes to a cost assessment, the cost assessors usually have them for at least a few months before they come back again.
Thank you.
So do you advise complainants their complaints will be sent directly to the lawyer they are complaining about?
Yes.
Absolutely.
Yes.
Yeah.
Yes.
Yeah. Quite why a complainant would think their complaint would not go to the person they're complaining
Yes, we've
about.
had some people who've wanted it not to go to the lawyer, but I've had to ring them up and explain that we can't do it that way.
Sort of the nature of a complaint. I am going to have to tell them. Sheepers. Hang on, what's this one say? How common is it for lawyers to be legally represented when responding to complaints? I'd say the majority would deal with their own complaints, right?
Yes. Yep.
Yep.
Less than half.
The ones that are more serious, you tend to see insurance lawyers, law firms coming in, and occasionally we get submissions by barristers on behalf of people, QCs. Sometimes you wonder why the person didn't get some assistance when they're really not seeing the point. Sometimes you honestly wonder why the person did think they needed assistance. But it's, universally, when people get assistance, you tend to have a better quality answer, if only because it's not you. you don't know what you don't know. If you think you're responding to stuff and you've missed something out, you're never going to get it spotted by you, are you? And that's one of the sort of, I think if you looked at the materials that Susan sent around the very first lot, there's a panel of lawyers that were on a list of, ring them and they'll talk you through the process and show you how it can work and what you should do and give you a bit of advice. There'll be people that know how it works. There'll be people that can probably talk to you about your issue and say, you know, that sounds pretty serious. Maybe you should just go and see someone. The funny thing is, when the more sort of senior counsel you see being involved, you can obviously see that there's some really good lawyers that are able to confront their clients. You've got an issue here. This is not going to go away. A strategy for you might be to confess, avoid, apologise, get shot of this. That might be the better approach here than hanging on to this thin legal argument that you think might sound terrific but really honestly isn't. And some of the QCs that are involved, you get a very concise thing that actually just says, yep, accept there's a problem there. Would happily, well not happily, but would, like to keep the penalty low, but suggest because this person's got an exemplary record, maybe the committee would like to go a bit easy. And I think the committees I've sat on are mindful about those sort of things. There's some like in particular at the moment, the trust account stuff's really regarded as very serious. Even just the not reporting your dormant balances every year, and the dormant balances, even tiny dormant balances, the LCRO has basically made that super clear that that's just unsatisfactory. You're looking after someone else's money. You need to be scrupulous about doing that. And that message is slowly getting through. Same with the transparent billing stuff. When the Law Society has sent around copious amounts of data to people about not disguising disbursements and being completely clear about what your office expenses cover. But we had a lawyer that just made up a land tax. $100 land tax on every bill. What do you do with that?
Do most people that have put complaints through, do most people that have made complaints to the Standards Committee, have they usually already complained to the lawyer and the lawyer hasn't done anything about it? Or do people quite often just go straight to make that complaint to the Law Society?
Sometimes it's unclear. A lot of the time it's straight to the Law Society. Sometimes there is engagement where the lawyer's just clearly not listening, or the relationship by then so spent that they're just at loggerheads, or there's a fee issue or something like that. I think it's telling that you don't see the complaints against the big firms, because I'm sure they have complaints, but they will have processes that deal with it better than others.
Thank you.
1, 2, 3. 1.
Julian, we've got a question here.
Yeah.
That awful letter from Mr. Wormwood number 2, would you actually get lawyers writing stuff like that to a Standards Committee?
Yep, that's based on a true letter. We changed the words a bit and maybe adjusted the sexes of people, but yep.
It's just,
I think that's a very important point. This is not daydreaming. This thing actually happens. And it gets worse than this one. This is quite mild in some cases.
This question's for David. I was very interested in what you said about underutilised parts of the legislation. You actually said negotiation and conciliation weren't being used enough. Now, in the context of this particular complaint, my impression was that the real complaint was nobody's listening to me, and that when he got the decision from this panel, he was going to be confirmed that nobody was listening to him, and then he would start to complain about the panel, and he would then become somebody who was against the profession.
Yes.
And would you think it was appropriate to actually have a formal listening process to that man?
That's a really good question, because we're potentially ending up with another unhappy person. I agree. Gee, I know, and Susan will help me here, there have been occasions where the committee was conscious of how a complainant was going to receive an outcome, haven't we been? And have, I think it's sometimes fallen to the LSO to be part of the communication back to the
But we
complainant.
try to give a fully reasoned
Yes.
decision, and probably in this example we were probably a bit more flippant than we normally, would get.
Yeah.
We couldn't sit here for the amount of time that we would normally discuss it, but we try to give a reasoned decision so that the person receiving it can understand. They don't just get told no further action. They go through the reasons why we've decided to take no further action.
In his complaint, his real complaint was he couldn't afford a lawyer to increase his share under the will. That was his real complaint, and that totally slipped below the surface, and nobody has addressed that complaint.
That he couldn't afford a lawyer to.
Couldn't afford a lawyer to increase his share
Who's this?
under the will.
Mr.
Chapman.
Chapman.
Was it?
I didn't know. Did you?
Wow.
If he wants legal advice, he can't come to us because we're not. We can't give people legal. We're not acting as lawyers. We're just dealing with complaints. And if somebody's wanting legal advice as to whether they should challenge a will, then we'll have to say, you need to take your own legal advice on that. Because often we get complaints about wills and about that the person didn't have testamentary capacity. That's a common one, that Mr. X drafted a will when my mother didn't have testamentary capacity, and that's something that has to be tested in the court, not before a standards committee. We can look at whether the lawyer took the proper inquiries as to whether there was testamentary capacity, but we can't determine whether the person had testamentary capacity.
So
or not.
people read the Wormwood one as though Chapman had a different sort of complaint. So did Chapman didn't, I don't think, but we were close to it. But if that had happened and your letter summarising the issues goes to the complainant and they're not seeing their issue there,
they will often
come back and say,
often you do complain, oh, you've missed this or something. They'll come up and tell me that they want another issue included, and then I will write to the lawyer and say the complainant wants this other issue included. Because some of the letters are very long and involved, and it's you've got to work out that you've covered everything in a 20-30 page letter.
Because the society doesn't, or the complaint form and the process doesn't require people to identify the rules or anything like that. It just says, tell us what's happened and what you want, which is inevitably something like strike him off, discipline him, shouldn't be a lawyer, all this other stuff. So people never really look at what you can do, because we can't do any of that. And then, so an ordinary people don't really have an ability to know whether they got a conflict issue or this issue or a unprofessional conduct issue or a bit of negligence. So that's sort of the job of the LSO and the committee when we first look at it, having read it. What is this all about? Are these issues the right ones? Are they identified properly? Is this a competence issue? Is it a conflicts? Is it a breaking the rules, a trust accounting one?
But those issues go to the complainant and the lawyer. So if the complainant thinks we've missed an issue, then they will come back and tell us we've missed an issue.
I'd just like to make a comment. I'm sorry. You've raised a very important point, how you see it this way and I see it entirely differently, and it's possible Julian might see it a different way again. And this is the difficulty, because we're all human. I didn't see that at all, but it doesn't mean say I'm right or you're wrong. It means we're seeing it differently, and that's got to be handled in the process. And from my observation is that generally it is. You don't see many things popping up and saying, well, I see it this way or I see it that way. But you raise a very interesting point, how we see things on documents differently.
Well, what I saw was that this is a lay person. He had been spending the latter years of his life looking after his elderly mother, who I gather was 102. He is not going to see anything in a legal sense.
No.
His problem was a very simple one, which could be classified as it's not fair.
That's true.
And it then became, well, I don't think my sister should have exactly the same as I'm going to get. And suddenly you were into a human relationships problem, which is not a legal category, it's a human category. And that's where I see the presence of the lay members as being so important, to get the lawyers off the legal categories and onto the human communication problem, which fires this whole complaint, but isn't going to stop there when you say an end. It's going to continue, and it's going to continue to burn the relationship of the users with the legal profession.
Yes, that could be well true, but with human issues, that's often an end consequence. No matter how they're handled, people go away feeling happy or they feel aggrieved. They've then got to have the chutzpah, it's a nice way of putting it, to keep pushing, and often they don't.
Yeah. So if you are notified there was a complaint, clearly unfounded, but has already been withdrawn, does it remain on record? How does a withdrawn complaint impact
Well,
the lawyers?
once it's gone to it has to go to the Standards Committee. A withdrawn complaint will, I would just send it to, would go on the next meeting, and the agenda note would say, this was the complaint, but the complainant has advised that it's been withdrawn, and then the committee again just determines whether there's any public interest issues in pursuing it, because once you've made a complaint, it becomes part of the complaints process, and it's not like a civil case that you can withdraw again, because we're disciplinary, but it will go to the committee, and probably 99% of the time they would say no further action, it's been withdrawn.
But a withdrawal complaint stays on the database.
It does stay on the database until it's gone to a Standards Committee.
And then what happens?
And then it's no further action.
So
and
an
it's
NFA,
closed.
has an NFA affect a lawyer's disciplinary record?
It doesn't. Disciplinary record only covers findings. No further action doesn't go on your record.
Yeah. And when I think you mentioned it, but when the committee decides that we're going to make a finding of unsatisfactory conduct, so this will be at a hearing, so Susan will be prepared for that as a possible outcome. You will have that lawyer's disciplinary record.
Yes, whenever something goes to a hearing on the papers, before the meeting I'll prepare a disciplinary record for the lawyer, and that will include all findings that have been made against him or her. No further actions are not included in that. The committee does not see that unless they make a finding, and they can only take that into account when determining penalty. So they don't see the disciplinary history until they've made a finding.
As a rule of thumb, how do you handle an anonymous complaint about a particular lawyer? Do you take that complaint seriously?
An anonymous complaint.
So it's not signed, it's detailed.
Yeah, it's very difficult to take further because you've got nobody to provide evidence to back it up. You've probably just got to bear allegation, unless they could, if they've got enough information there to make it be something that a committee would be concerned about, it would go to a committee to bring an own motion.
Say there was a decision in the NZLRs that had some paragraphs that talked about the behaviour of a particular lawyer. If someone printed that decision and put it in an unmarked envelope and shoved it under the Law Society's door, highlighting the paragraphs,
yes.
I'm assuming that would end up in front of some committee at some point.
Yes, it would go. Yeah, it would go down to Wellington, and they would look at it. And if they thought that there was something there that a committee should look at, it would be allocated to a committee to open as an own so it would be treated as an own motion investigation.
I'm thinking more of a letter from Joe Bloggs, unsigned, obviously, complaining about a particular lawyer. Would you write to that lawyer saying a complaint has been made?
It wouldn't be treated as a complaint unless unless we could identify the person, just for natural justice reasons. Yes. The lawyer needs to know who it is, I think.
Thank you.
So it's sort of related. How did Rule 2.8 functions relate to complaints functions? I'm aware of 2.8 reports being treated as complaints, and of standard committees saying they don't know why the lawyer had thought they had to make a complaint.
A 2.8 is a unsatisfactory conduct one, isn't it? Or was that
No, it's the
2.7? Oh, okay, the 2.9. It's not. It would be treated as a complaint if the person making it wanted it to be a complaint. Otherwise, it would go, if the person wanted to remain anonymous, it would go as an own motion investigation. If it could be dealt with, if there was sufficient there to enable that to be, but people are, if someone puts in a report, they will be warned, that we have to send this to we have to send your letter to the person. We can delete your name out of it, but obviously, often the lawyer will know who it's from anyway. Yes.
Yeah, I think lots of professions actually struggle with that sort of the transparency of the process, and should someone wants to complain but wants to keep it confidential, that's completely inconsistent with actually promoting and making people accountable for what they say, right? An anonymous complaint could be the worst thing in the world that's completely untrue, and there's no accountability, there's no nothing, there's no way to verify it. So I think the law side would take those sorts of things, frankly, with a grain of salt. If you're prepared to, though, come forward and make a complaint, it's also, you should have courage of your convictions. Transparency in that sort of area is the only way to actually promote that sort of thing.
Well, if you're required by the rules to put this before the committee, if you're required by the rules to put something to the
It doesn't
Law
have
Society,
to be a complaint, though. You can do it as just a
report.
report. Yes,
Okay.
and then it would go as own motion. Yeah.
Okay.
I can say that at a personal level, I would be very hostile to an anonymous complaint because it's just too easy. I mean, being a whistleblower is one thing in Washington, but being a whistleblower here, I think that's dangerous territory.
I just know of a lawyer who's obviously his wife wrote an anonymous letter saying he does this, he does that in his finances or whatever, and he did actually get a letter saying a complaint has been made about you, and this is what the complaint is, and copies were sent to him, which surprised me, considering it was anonymous, and obviously he knew exactly whom it was. This is hence my question. But I would agree, I wouldn't consider it.
We sort of live in a funny world nowadays where you're trying to make it easy for people to complain, but and that you sort of have the this empowerment of the keyboard warrior that actually if they're put to the test, then actually they're not so passionate about it. We've had complaints where because of delays and things going to the LCRO and then coming back again, the complainant's long since gone and lost interest, but the process has been started, and you write to them, don't you, and ask them if they and it's no response from the complainant. You're left with this thing this zombie file that's come back, because the LCRA had this really weird practice at one point. I'm not sure they've done it recently, but very old files, instead of just shutting them down after they've done their full investigation of them, and a fuller investigation than maybe the Standards Committee would have done, they go, we think the Standards Committee got it right on this one, but this bit they got it wrong, so we'll send it back to them. And my committee, I had files that I wasn't even in the committee.
No, nobody was on the committee
from
when the first
one was, and it comes back and it's going, anyone remember this? Well, it was no. This was blame David in the early days of when he was doing it.
David was the only one.
Yeah,
it's our longest member.
And I think they've stopped that practice now because they've got more up to date with their workload, and maybe someone observed to them it's not really very helpful. There's been some sort of things where I think there's been judicial reviews of files just coming out of nowhere, and everyone long since sort of had gone. You're years down the track, and it's impossible to then deal with those things. And the High Court, I think, have thrown those out and said, yeah, it's properly reviewed, breach of natural justice and all that sort of stuff. So,
if we can do a couple more questions from the live stream,
from the
that would
live
be great
stream,
before we
I'm
finish
still
off.
struggling with your phone though. Hang on. How often are lay persons persuaded by telephone to withdraw their complaints? I am aware of this happening quite recently. Oh. Have you ever got a telephone call from a complainant?
I'd be very worried if I had.
Oh, sorry, hang on. So this isn't talking about you guys. Oh, the complainants. Yeah.
To withdraw their complaint. I'd think that would be quite unusual. Unless it was one of those ones that came within the ERS, it was a misconceived complaint or something. Whether they thought it was not, because normally if it's a complaint, we'll investigate it.
There's not that sort of thing that used to exist where there'd be the guy that would ring them and have the little chat. That's the old way it used to be. There was wasn't it?
A long time ago.
Yeah, a long time ago. No, we won't do that one. If the committee comes up with fresh issues during its meeting, is there a process to ensure practitioners are given the opportunity to comment before adverse findings are made?
Yes.
Absolutely.
Definitely,
yeah.
if there's fresh issues, even if it's a notice of hearing and you're hearing on the papers, and the committee decides there's something that's not in the hearing of the papers, it wouldn't make a finding on it. It would adjourn the meeting and issue a fresh notice of hearing to give the people.
If anything, I think my reflection on the process is that natural justice is almost overdone, in the sense of making it absolutely clear. And if there's any doubt that the lawyer isn't aware of the things that need to be responded to, you would do a fresh notice of hearing. Stop where you're at and start again. Yeah.
Another one, Julian.
Is the Law Society, I don't know about that one, what about something that's within the ambit of the original complaint but outside the issues enumerated by the Legal Standards Officer in the initial covering letter?
Well, that's not a problem at the initial hearing, because those ones in the covering letter are just for guidance. So when it went to the notice of hearing, the committee would clarify the issues, and that would be put in. Again, if it was at the notice of hearing, when often something comes up out of the submissions that have been made, and we think, oh well, that actually the issue's not that, it should be that, then the hearing would be adjourned and a fresh notice of hearing issued.
We've had issues where, I can remember one where the lawyer made comments and didn't think it was the sort of Fair Trading Act rule equivalent, but thought it was the integrity rule, the one later about there's that curious rule where you can't mislead about the nature of your practice.
Nature of your practice.
Which is more sort of aimed at the fair trading thing, as opposed to, and there's another rule that sort of covers a similar area. And I think we had one where in the submissions the lawyer had observed that they didn't think it was rule
that rule,
X
it
issue,
should have been
but
that
it was
rule,
the other issue. So we took submissions on whether the conduct fell within the other rule.
Set it down for hearing on the papers, we asked for submissions on all the rules.
Yeah.
We're about 6 o'clockish.
I thought there was one over
Was there any
here.
more in the room that wanted questions?
If we do have time for one more, can we do that
From the live stream.
Okay, so when the committee considers a review of the file as necessary, does the complainant provide a clode letter waiving legal privilege?
No, we don't need to waiver. If the
complainant is the client,
we don't need a waiver of privilege.
Sometimes there are situations where it's a non-client complainant and the lawyer's put into some difficulties because they want...
Yeah, probably where you get the beneficiary complaint, where the beneficiary's complaining about the lawyer and the lawyer... But it's been taken that it's subject to legal professional privilege, so the lawyer is entitled... Well, the client
is entitled to that privilege, right?
Not the lawyer. So we would expect the lawyer to ask the client to waive privilege.
If the lawyer thinks to defend themselves they would need that privilege waived, right? But have we ever had problems with that? When we sort of say to the lawyer, well, it'd be really good that you then spoke to the actual client, please, and get a waiver of privilege. It's just confidential to us.
Privilege is a bit tricky. Like I know there's a matter before the courts at the moment where... because we've taken the view that it's subject to legal professional privilege, and if the privilege is there, we can't take it further. But I think the LCRO or someone has challenged. There's been a challenge to that, which is in the courts at the moment.
Okay.
But generally, we will say, if we're issuing a 147, we always say that's subject to legal professional privilege.
We've had lawyers maintain privilege over. As against the client complaining about bills over the bill narrations, haven't we?
No, that was a beneficiary
complaint.
beneficiary
of... right. Okay.
I think you've all had a long day and we've covered quite a lot of ground here.
Yes.
And I just don't want to get to the stage
we have gone over.
You're thinking, where's the door?
Okay, are we done? Okay. Is that good?
Thank you everybody for coming. We'll be sending out an evaluation form in the next couple of days, so please take the time to fill that in and help me thank our fantastic speakers.